Title 18 Damages, Chapter 1 General Provisions, 2195. The provisions of this title shall be respectively applicable to all obligations mentioned in Article 1157, 2196. The rules under this title are without prejudice to special provisions and damages formulated elsewhere in this code. Compensation for workmen and other employees in case of death, injury, or illness is regulated by special laws. Rules governing damages laid down in other laws shall be observed in so far as they are not in conflict with this code. 2197. Damages may be 1. Actual or compensatory, 2. Moral, 3. Nominal, 4. Temperate or moderate, 5. Liquidated, or 6. Exemplary or corrective. 2198. The principles of the general law on damages are hereby adopted in so far as they are not inconsistent with this code. Chapter 2. Actual or compensatory damages. 2199. Except as provided by law or by stipulation, one is entitled to an adequate compensation only for such pecuniary loss suffered by him as he has duly proved. Such compensation is referred to as actual or compensatory damages. 2200. Indemnification for damages shall comprehend not only the value of the loss suffered, but also that of the profits which the obligee failed to obtain. 2201. In contracts and quasi-contracts, the damages for which the obligor who acted in good faith is liable shall be those that are the natural and probable consequences of the breach of the obligation in which the parties have foreseen or could have reasonably foreseen at the time the obligation was constituted. In case of fraud, bad faith, malice, or wanton attitude, the obligor shall be responsible for all damages which may be reasonably attributed to the non-performance of the obligation. 2202. In crimes and quasi-delicts, the defendants shall be liable for all damages which are the natural and probable consequences of the act or omission complained of. It is not necessary that such damages have been foreseen or could have reasonably been foreseen by the defendant. 2203. The party suffering loss or injury must exercise the diligence of a good father of a family to minimize the damages resulting from the act or omission in question. 2204. In crimes, the damages to be adjudicated may be respectively increased or lessened according to the aggravating or mitigating circumstances. 2205. Damages may be recovered 1. For loss or impairment of earning capacity in cases of temporary or permanent personal injury. 2. For injury to the plaintiff's business standing or commercial credit. 2206. The amount of damages for death caused by a crime or quasi-delict shall be at least 3,000 pesos even though there may have been mitigating circumstances. In addition, 1. The defendant shall be liable for the loss of the earning capacity of the deceased, and the indemnity shall be paid to the heirs of the latter. Such indemnity shall in every case be assessed and awarded by the court unless the deceased on account of permanent physical disability not caused by the defendant had no earning capacity at the time of his death. 2. If the deceased was obliged to give support according to the provisions of Article 291, the recipient who is not an heir called to the decedent's inheritance by the law of testate or intestate succession may demand support from the person causing the death for a period not exceeding 5 years, the exact duration to be fixed by the court. 3. The spouse, legitimate and illegitimate descendants and ascendants of the deceased may demand moral damages for mental anguish by reason of the death of the deceased. 2207. If the plaintiff's property has been insured and he has received indemnity from the insurance company for the injury or loss arising out of the wrong or breach of contract complained of, the insurance company shall be subrogated to the rights of the insured against the wrongdoer or the person who has violated the contract. If the amount paid by the insurance company does not fully cover the injury or loss, the aggrieved party shall be entitled to recover the deficiency from the person causing the loss or injury. 2208. In the absence of stipulation, attorneys' fees and expenses of litigation, other than judicial costs, cannot be recovered except 1. When exemplary damages are awarded, 2. When the defendant's acts or omission has compelled the plaintiff to litigate with third persons or to incur expenses to protect his interest, 3. In criminal cases of malicious prosecution against the plaintiff, 4. In case of a clearly unfounded civil action or proceeding against the plaintiff, 5. Where the defendant acted in gross and evident bad faith in refusing to satisfy the plaintiff's plainly valid, just, and demandable claim. 6. In actions for legal support. 7. In actions for the recovery of wages of household helpers, laborers, and skilled workers. 8. In actions for indemnity under workmen's compensation and employers' liability laws, 9 in a separate civil action to recover civil liability arising from a crime, 10 when at least double judicial costs are awarded. 11. In any other case where the court deems it just and equitable that attorneys' fees and expenses of litigation should be recovered. In all cases, the attorneys' fees and expenses of litigation must be reasonable. 2209. If the obligation consists in the payment of a sum of money and the debtor incurs in delay, the indemnity for damages, there being no stipulation to the contrary, shall be the payment of the interest agreed upon, and in the absence of stipulation, the legal interest, which is 6% per annum. 2210. Interest may, in the discretion of the court, be allowed upon damages awarded for breach of contract. 2211. In crimes and quasi-delicts, interest as a part of the damages may, in the proper case, be adjudicated in the discretion of the court. 2212. Interest due shall earn legal interest from the time it is judicially demanded, although the obligation may be silent upon this point. 2213. Interest cannot be recovered upon unliquidated claims or damages, except when the demand can be established with reasonable certainty. 2214. In quasi-delicts, the contributory negligence of the plaintiff shall reduce the damages that he may recover. 2215. In contracts, quasi-contracts, and quasi-delicts, the court may equitably mitigate the damages under circumstances other than the case referred to in the preceding article, as in the following instances. 1. That the plaintiff himself has contravened the terms of the contract. 2. That the plaintiff has derived some benefit as a result of the contract. 3. In cases where exemplary damages are to be awarded, that the defendant acted upon the advice of counsel. 4. That the loss would have resulted in any event. 5. That since the filing of the action, the defendant has done his best to lessen the plaintiff's loss or injury. Chapter 3. Other kinds of damages. 2216. No proof of pecuniary loss is necessary in order that moral, nominal, temperate, liquidated, or exemplary damages may be adjudicated. The assessment of such damages, except liquidated ones, is left to the discretion of the court, according to the circumstances of each case. Section 1. Moral damages. 22. Physical suffering, besmirched reputation, wounded feelings, moral shock, social humiliation, and similar injury. Though incapable of pecuniary computation, moral damages may be recovered if they are the proximate result of the defendant's wrongful act for omission. 2218. In the adjudication of moral damages, the sentimental value of property, real or personal, may be considered. 2219. Moral damages may be recovered in the following and analogous cases: 1. A criminal offense resulting in physical injuries. 2. Quasi-delicts causing physical injuries. 3. Seduction, abduction, rape, or other lascivious acts. 4. Adultery or concubinage. 5. Illegal or arbitrary detention or arrest. 6. Illegal search. 7. Libel, slander, any form of defamation. 8. Malicious prosecution. 9. Acts mentioned in Article 309. 10. Acts and actions referred to in Articles 21, 26, 27, 28, 29, 30, 32, 34, and 35. The parents of the female seduced, abducted, raped, or abused, referred to in number 3 of this article, may also recover moral damages. The spouse, descendants, ascendants, and brother and sisters may bring the action mentioned in number 9 of this article in the order named. 2220. Willful injury to property may be a legal ground for awarding moral damages if the court should find that, under the circumstances, such damages are justly due. The same rule applies to breaches of contract where the defendant acted fraudulently or in bad faith. Section 2. Nominal damages. 2221. Nominal damages are adjudicated in order that a right of the plaintiff, which has been violated or invaded by the defendant, may be vindicated or recognized, and not for the purpose of indemnifying the plaintiff for any loss suffered by him. 2222. The court may award nominal damages in every obligation arising from any source enumerated in Article 1157 or in every case where any property right has been invaded. 2223. The adjudication of nominal damages shall preclude further contest upon the right involved in all accessory questions as between the parties to the suit or their respective heirs and assigns. Section 3. Temperate or moderate damages. 2224. Temperate or moderate damages, which are more than nominal but less than compensatory damages, may be recovered when the court finds that some pecuniary loss has been suffered but its amount cannot, from the nature of the case, be proved with certainty. 2225. Temperate damages must be reasonable under the circumstances. Section 4. Liquidated damages. 2226. Liquidated damages are those agreed upon by the parties to a contract to be paid in case of breach thereof. 2227. Liquidated damages, whether intended as an indemnity or a penalty, shall be equitably reduced if they are iniquitous or inconsolable. 2228. When the breach of the contract committed by the defendant is not the one contemplated by the parties in agreeing upon the liquidated damages, the law shall determine the measure of damages and not a stipulation. Section 5. Exemplary or corrective damages. 2229. Exemplary or corrective damages are imposed by way of example or correction for the public good, in addition to the moral, temperate, liquidated, or compensatory damages. 2230. In criminal offenses, exemplary damages as a part of the civil liability may be imposed when the crime was committed with one or more aggravating circumstances. Such damages are separate and distinct from fines and shall be paid to the offended party. 2231. In quasi-delicts, exemplary damages may be granted if the defendant acted with gross negligence. 2232. In contracts and quasi-contracts, the court may award exemplary damages if the defendant acted in a wanton, fraudulent, reckless, oppressive, or malevolent manner. 2233. Exemplary damages cannot be recovered as a matter of right. The court will decide whether or not they should be adjudicated. 2234. While the amount of the exemplary damages need not be proved, the plaintiff must show that he is entitled to moral, temperate, or compensatory damages before the court may consider the question of whether or not exemplary damages should be awarded. In case liquidated damages have been agreed upon, although no proof of loss is necessary in order that such liquidated damages may be recovered, nevertheless, before the court may consider the question of granting exemplary in addition to the liquidated damages, the plaintiff must show that he would be entitled to moral, temperate, or compensatory damages were it not for the stipulation for liquidated damages. 2235. A stipulation whereby exemplary damages are renounced in advance shall be null and void.